Good evening and welcome. It is time once again for CU Immigration here on WRFU LP Urbana 104.5 FM and UPTV. I should let you know that WRFU is an open forum for the Urbana-Champaign community. Views expressed are those of the speakers and are not intended to represent WRFU or UCIMC, or, as we like to say on the televised version of this show, UPTV. These views are our own. And by our, in this instance, I mean myself. Your host, my name is Mr. Garza, and I'm here to share some information about immigration. So, let's begin today with what could be the biggest news of the day. This is entitled, Supreme Court Won't Hear Case on California Sanctuary Law. The Supreme Court on Monday, today, when I'm recording this, turned down an appeal from the Trump administration seeking to challenge a California sanctuary law. As is the court's custom, its order declining to hear the case gave no reasons. Justice Clarence Thomas and Samuel A. Alito Jr. said they would have granted the administration's petition seeking review. The California law prohibits state officials from telling federal ones when undocumented immigrants are to be released from state custody and restricts transfers of immigrants in state custody to federal immigration authorities. A unanimous three-judge panel of the United States Court of Appeals for the Ninth Circuit in San Francisco ruled that the federal government is not entitled to commandeer a state's resources to further its immigration agenda. Judge Milan D. Smith, Jr., writing for the panel, acknowledged that the state law may well frustrate the federal government's immigration enforcement efforts. However, he wrote, whatever the wisdom of the underlying policy adopted by California, that frustration is permissible because California has the right. The Trump administration told the Ninth Circuit that Congress, in enacting immigration laws, expected that states would cooperate with the federal government. That is likely the case, Judge Smith acknowledged. But when questions of federalism are involved, we must distinguish between expectations and requirements. In this context, the federal government was free to expect as much as it wanted, but it could not require California's cooperation. In a petition seeking the Supreme Court review of the case, United States v. California, number 19-532, lawyers for the Trump administration wrote that the state law conflicted with federal ones and posed a risk to public safety. When officers are unable to arrest aliens, often criminal aliens, who are in removal proceedings or have been ordered removed from the United States, those aliens instead return to the community where criminal aliens are disproportionately likely to commit crimes, the petition said. The result undermines public safety, immigration enforcement, and the rule of law. In response, lawyers for California said the federal government was not entitled to take over the state's resources. The federal government may not require the state and its political subdivisions to provide information or transfer individuals to federal immigration authorities because doing so would conscript state and local officials into enforcing federal removal policies that would deny them the choice to decline to implement a federal regulatory program, the state's brief said. The threat to public safety, the state's lawyer said, would arise from cooperation with federal agents. The state law, they said, was adopted to address concerns that undue entanglement with immigration enforcement can deter victims and witnesses from reporting crime, state crimes, and divert limited resources from other activities that the legislature has determined will better protect local public safety. Now, I won't go into a long editorial about the Trump administration's comments, but I noticed the use of the term aliens, often criminal aliens. So the way they're stating this is that the state is, for some reason, some unfathomable reason, releasing criminals into, this is into society without any concern about the fact that they're criminals. So the comment where criminal aliens are disproportionately likely to commit crimes is just ludicrous. I don't know what they're basing that on. They don't state what they base that on. It's just an assumption. But the criminal aspect to a lot of these people is the fact that they have immigration offenses, let's say. So they've come in without being recorded as coming into the country. I forget the exact term for that, but or they've been ordered removed and they've come back or something like that. So the notion that these are criminals derives solely from, in most cases, solely from their immigration crimes, as it were, in terms of how they have or have not followed immigration law, existing immigration law. So it's a huge stretch, an enormous stretch, to say that somehow that because they are criminals, and I'm doing air quotes here for anyone who can't actually see me on TV, they are disproportionately likely to commit crimes. Well, they're given that their crimes are disproportionately immigration related, to that extent, yes, they are likely to continue committing crimes based around ignoring immigration law, ignoring immigration authorities, etc. But they're not likely to commit other kinds of crimes, like property crimes, shooting people, stealing things, all that sort of thing, which is what they're implying here. So the implication is that the people here being discussed are somehow of a more violent or dangerous type than other people who may be in jail or in prison. And that is simply not the case. And it is a huge stretch to try to make that claim that this is so. If the state of California arrests someone, that person serves their time for whatever they were arrested for, then they are considered to have finished the process and be free again. And so California wanting to free people when they have satisfied the laws of California is perfectly reasonable. And just because the federal government has adopted this different sense of who these people are or how they should be treated doesn't mean that California should necessarily follow suit. And I think that's what this case is about. And I think that's what the bulk of the Supreme Court anyway agreed enough with that they didn't want to carry it any further. It's not a surprise that Thomas and Alito are both the dissent on that, because we all know where they're coming from. Anyway, I'm going to move on. I promised I wouldn't editorialize too much, but it really bothers me to read some of these statements and not at least push back on them in some way, because they're kind of ludicrous. Anyway, so this is a bit of a twist. This is entitled "The Surprising Origin of Our Modern Nation of Immigrants." So we think of this as a nation of immigrants a lot of times, and that's how it is described quite often. But it's kind of interesting to explore that idea a bit. So that's what this story is about. And it reads as follows. It was early evening when Michael Fagan arrived at the White House on May 7th, 1965. A tall, dour Democratic congressman from Ohio, Fagan had an important meeting with President Lyndon B. Johnson. For months, Johnson and his aides had been hounding Fagan over his resistance to one of the president's top priorities, passing the most consequential immigration bill in nearly half a century. The proposed law would abolish the 1924 National Origins Act, which put in place a system of ethnic quotas to codify America as a white Protestant nation. The 1924 system greatly curbed the entry of Jewish, Italian, African, and Asian immigrants while offering far more slots to immigrants from Northern Europe. To Johnson, these quotas were nakedly unjust, akin to the Jim Crow laws restricting the political rights of black Americans in the South, another system that he was trying to dismantle. But Fagan was nervous. If the country was going to get rid of the quotas, he believed it still needed a way to control its racial makeup. And so he offered a compromise. What if the country prioritized entry for people with family already in the United States? This way, Fagan reasoned, the country's ethnic balance could change only so much, since most Americans were white, their family members abroad would also be white. Johnson accepted the deal, which avoided scaring off pro-immigration liberals while easing the concerns of immigration restrictionists in Congress. 4 months later, at the foot of the Statue of Liberty, the president signed the compromise into law as the 1965 Immigration and Nationality Act, abolishing the 1924 quotas. This bill that we will sign today is not a revolutionary bill, he promised. It does not affect the lives of millions. But what happened over the following decades would surprise nearly everyone. The system of family preference that Fagan had insisted upon, hoping to sustain America's white identity, instead opened the door to Asian, Latin American, African, and Middle Eastern immigration at a scale never seen before. Demographers now predict that non-white Americans will outnumber white Americans within 3 decades. Ever since his inauguration, Donald Trump has been fixated on ending what immigration conservatives call chain migration, the very system Fagan had seized as a way to limit non-white immigration. Recently, Trump administration officials have seized on the coronavirus pandemic as a pretext for reshaping the immigration system. In April, Mr. Trump signed an executive order suspending family-based immigration for parents and siblings of citizens. Many have denounced Mr. Trump's policies as an aberration from the ideal of a nation of immigrants, a phrase popularized as the title of a pamphlet written by John F. Kennedy that became a bestseller when it was published posthumously in 1964. But the United States has always struggled to balance different visions of what the country could or should be. Who should be let in, and who can participate in civic life? Should the country allow new immigrants based primarily on economic and humanitarian need, or based on applicants' useful technical abilities or their family ties? Does the country's ethnic makeup matter at all? Since the passage of the 1965 law, the reunification of families has been a core principle of American immigration policy. From 2007 to 2016, about 7 million out of the nearly 11 million immigrants who obtained green cards did so through family ties, according to data from the Department of Homeland Security. The presumptive Democratic presidential nominee, Joe Biden, has vowed to preserve the long-standing directive of our immigration system to reunite families and enhance our diversity. Even amid a resurgence of right-wing nationalism, that is a remarkable departure from the politics of 1965. 3 months before his meeting with President Johnson, Fagan, the Ohio Democrat, appeared before an influential group called the American Coalition of Patriotic Societies, which supported the 1924 quota system. In his speech, Fagan attacked the quotas as a myth that failed to effectively preserve the country's white status quo. He cited China, for instance, which had an official quota of about 100, but was sending more than 2,000 people a year into the United States because of various exceptions. And he vowed to eliminate the quota system altogether and replace it with something that would truly work to keep out non-white immigrants. Supporters of the bill played down its potential to change the country, emphasizing instead that ending the quotas was simply the right thing to do, a symbolic measure that that Jewish and Italian Americans had earned their rightful place in American society. Foreign policy experts in Washington argued that an explicit policy of racial discrimination made it harder to win allies during the Cold War. Secretary of State Dean Rusk testified before Congress that the quota system telegraphed to the world that our standards of judgment are not based on merit, but rather on bias and prejudice. When asked about the potential effect of abolishing strict limits on Asian immigration, Robert Kennedy, then the Attorney General, estimated there would be about 5,000 immigrants in the first year, after which immigration from that source would virtually disappear. This underestimate was premised on the low number of Asian immigrants who were on the waiting list for an open slot under the existing quota system. But the lists were so short only because, with such a small contingent of Asian Americans allowed, few bothered to apply. A small contingent of Asian immigrants allowed, few bothered to apply. As Congress debated the reform bill, not everyone missed its potential impact. Sam Ervin, a segregationist senator from North Carolina, worried that if there were more immigration from Africa and Asia, the country would be drastically changed. Strom Thurmond of South Carolina staked out an anti-immigration position in defense of the quotas. Every country, he argued, had the right to determine its own ethnic makeup. The wish to preserve one's identity and the identity of one's nation requires no justification, and no belief in racial or national superiority, any more than to wish to have one's own children. But the bill had strong support from pro-immigration liberals, and with immigration restrictionists like Fayen on board, it easily passed once it came to a vote. It would be years before the transformative impact of the 1965 Immigration and Nationality Act would fully reveal itself, but by 1971, more Asians were entering the country than Europeans, and these immigrants were establishing roots across the country. New York's Chinatown boomed as new arrivals rushed in. 2 more Chinatowns arose in the city, one in the Flushing area of Queens and another in Brooklyn's Sunset Park neighborhood. Many Iranians, a large share claiming asylum after the overthrow of the Shah in 1979, settled in California and Texas. Arabs gravitated toward the Detroit area and took jobs in the American auto industry. By 1989, the top 10 countries sending immigrants to the United States were all in the so-called Third World, as immigration from Europe continued to taper. Over time, the demographic effects of the 1965 law have accelerated. 5 years ago, Pew Research estimated that without post-1965 immigration, the country would have been 75% white, 14% black, 8% Hispanic, and less than 1% Asian. Instead, it was 62% white, 12% black, 18% Hispanic, and 6% Asian by 2015. Today, immigration restrictionists, including former Attorney General Jeff Sessions, have praised the 1924 ethnic quotas while pointing to the 1965 law as unleashing far more change than the country desired. The truth is, few policymakers in 1965 anticipated the depth of demographic change the law would set in motion, but the law's most ardent supporters were not confused about the principle behind it. They believed eliminating race-based immigration restrictions was the right thing to do, and they viewed it as part of a larger effort to expand civil rights, something inextricable from the never-ending fight for equality in America. Our beautiful America was built by a nation of strangers, Johnson said on the day he signed the bill. From 100 different places or more, they have poured forth into an empty land, joining and blending in one mighty and irresistible tide. Okay, and I generally thought that was a really interesting and useful story. I have to push back on Johnson here at the end. As you might imagine, I'm going to editorialize a little bit that from 100 different places or more, they have poured forth into a not empty land. They've poured forth into a land that they have emptied as they poured forth into it. and did their best to completely empty, but didn't quite make it. So our nation of immigrants is also problematic in a way because there were already people here. And they didn't get to have any say in who came here and how any of that worked. So all of this stuff has been decided by and argued over by people who themselves came here and just sort of took a place here. So part of the immigration saga and the story and the discussions about it often leave out the fact that the people who come here and claim to represent the ethnic makeup of the country or this or that were people that came here and just took over. They weren't invited here. It wasn't an empty land, as Johnson put it. It was populated. It was used. It was the home of many, many different groups of people who were displaced by the people coming here. So to claim that there's some sort of foundation to this notion that we should try to maintain the ethnic balance of this country or something is just ludicrous, because it's just a window in time. It's just a snapshot in time of a majority white population, because most of the people that came here and stole the land were white. So that doesn't mean that they have some right to perpetuate their ethnic makeup or even their social structures or their religion or anything. I mean, you can't just come and take over and then say, well, now, because we've taken over, we have this right to hold this in perpetuity till the end of time. I mean, if this country is going to be a place where you can come into and see land that you like and lay a claim on it, regardless of who was here before and how that land was used before, then that would be, the thing that should continue on into the future, if you were going to say that there was some process by which people acquired the right to be American. If that process is come to America and lay a claim over the land, then that could and should continue on into the future. Some of us would argue that maybe none of that, all of that should be undone. That would be very difficult to do at this point, but if you're looking for heritage, if you're looking for some kind of starting point to say, well, this is where it began and this has set the tone for how it should be, it's a little disingenuous to make any claims about how America or the United States should be based on just one group's claims. Anyway, I don't know. It really opens up a big question, and it's difficult to go on into to expand on that into a larger issue, because some things can't really be undone. Some things can. Some things can be changed so that they're more equitable after they have been done. But it's really difficult. Once you've come in and wiped out a large proportion of the population and replaced it and unalterably changed the way the land was used, I guess unalterably might be a bit strong, but made it such huge changes that it would be very difficult. It would take many generations for the land to come back to anything like it was before Europeans came here. So it becomes very tricky, but I think all in all, what this boils down to is it's very, very, very hard for European descendant folks to claim that just sort of to pick an idealized moment in our history and say, well, this is America, and we should try to retain or remain like this into the future. That's just nonsense. There is no sound rationalization for that. If America is anything, since it became America, it's a place where people came to and decided they would make use of space in a way that suited them, regardless of how it suited or even affected the people that were there before and were using it in some other way. So using that logic, we should just have open borders and people should just come here and do whatever they want, because that's how America was formed and that's how it became what it is now. Anyway, I'm going to move on because I could talk about this all day. So I just have a few minutes left. The next thing is, in the Black Lives Matter movement, immigrants find themselves in a tough position. After the first wave of nationwide protests over George Floyd's death turned violent, immigrants on U.S. visas who support the Black Lives Matter movement faced a choice: to join the protests and jeopardize their legal status as immigrants, or sit it out and save their future in the country. Jennifer Scherl, a German immigrant living in Bellevue on a work visa, says she has always been a politically engaged person, especially having participated in Berlin's strong protest culture prior to arriving in the United States. The Black Lives Matter movement inspired her, but when things turned violent, she was forced to reconcile that with the realities of her visa status. I talked to my family and my partner about whether or not it's worth it for me to protest in person and risk the visa. We came to a conclusion that it would be detrimental to my personal well-being and my effectiveness here in the U.S. if I go back to Germany, she said. A foreign national in the U.S. is allowed to participate in peaceful demonstrations or rallies, and if they get arrested, the U.S. criminal justice system ensures that they are entitled to the same constitutional protections as a U.S. citizen. However, the immigration consequences of the arrest may be quite significant. If they get detained, arrested, or charged, it could be problematic, even if the charges were dropped, according to Parisa Karamet, an immigration attorney at Fragaman, an immigration law firm. They could be asked to disclose the arrest in an application for a visa or at a green card interview in the U.S. for any immigration benefits. Immigrants like Scherl are largely aware of how these situations could weigh heavily on their immigration status, which could curb their level of participation and their method of expressing their political opinion. This is a dilemma that immigrants are facing right now, says Andrea Flores, the Deputy Director of Immigration Policy for the ACLU. So many immigrants want to participate, but the risk is always there. It's important to protest and it's important to stay safe, but the decision is unfair to people who don't have enough protections due to their immigration status. Given the uncertainty that the Trump administration has placed on several visa categories, it's understandable that there is anxiety around participating in protests, she adds.